Get ready for the dictation on the count of 3, 2, 1, start. The award of pendent light interest and future interest was also unsustainable since the original amount was not in consonance with the terms of the contract and suffered from legal infirmity. Apart from this, the rate of interest awarded was very high and ought to have been interfered with by the learned single judge. There can be no dispute that an arbitral tribunal is required to decide a dispute strictly in accordance with the contract and in accordance with the substantive law for the time being in force. An arbitral tribunal is required to proceed fairly and in accordance with law, giving equal opportunity of representation to all the parties. In Shin Satellite Public Company Limited versus Masons Chair Studios Limited, reported in AIR 2006 to SCC 628, the Supreme Court held that a court of law would have to read the agreement as it is. The court cannot rewrite the agreement or create a new agreement. In Polymat India P Limited and ANR versus National Insurance Company Limited and ORS, reported in AIR 2005 SC 286 2005 9 SCC 176, the Supreme Court held that the terms of the contract have to be construed without altering the nature of the contract. In Delhi Development Authority versus Masons U.S. Sharma and Company, New Delhi, reported in 2008-13 SCC 80, the Supreme Court held that an award which was contrary to substantive provisions of law or the provisions of the 1996 Act or against the terms of the respective contracts or patently illegal or prejudicial to the rights of the parties was open to interference by court under Section 34(2) of the 1996 Act. An award could be set aside if it was contrary to the fundamental policy of law or the interest of India or justice or morality. An award could also be set aside if it were so unfair or unreasonable that it shocked the conscience of the court. It is open to the court to consider whether the award was against the specific terms of the contract and, if so, interfere with it on the ground that it is patently illegal and opposed to the public policy of India. Under the 1996 Act, the Learned Arbitral Tribunal is obliged to pass a reasoned award. There can also be no doubt that a mere statement of reasons does not satisfy the requirement of Section 31(3) of the 1996 Act. The reasons must be based upon materials submitted before the arbitral tribunal. The tribunal has to give its reasons upon consideration of the relevant materials, while irrelevant materials may be ignored. In Oil and Natural Gas Corporation Limited versus Western Gecko International Limited, reported in 2014 6 SCC 321 AIR 2015 SC 363, the Supreme Court reiterated that the phrase public policy used in Section 34 was required to be given a wider meaning. It could be stated that the concept of public policy connotes some matter which concerns public good and the public interest. What is for public good or in public interest, or what would be injurious or harmful to public good or public interest, has varied from time to time. However, the award, which was on its face patently in violation of statutory provisions, could not be said to be in public interest. such an award was likely to be adversely affected the administration of justice. The award could thus be set aside if it was patently illegal. There can be no doubt that an award which is patently illegal can be set aside. It is too late in the day to contend to the contrary. However, the award in this case does not appear to be patently illegal. In Bannari Amman Sugars Limited versus Commercial Tax Officer reported in 2005, 1 SCC 625, the Supreme Court held that where a particular mode was prescribed for doing an act and there was no impediment in adopting the mode, the deviation to act in a different manner without disclosing any discernible principles which were reasonable to be labeled as arbitrary. The Supreme Court reiterated that every state action had to be informed by reason